come to you here from Miami, Florida. Let me tell you a little bit about Tony. Tony works as an assistant federal defender in the Miami, Florida office. Prior to that, he was in private practice for many, many years, representing some of the folks who would be alleged terrorists, rock and roll stars, and the usual folks that people never talk about. Now, the nice thing about what we're going to hear this morning is that oftentimes we're all trying to explain what the hell it is that we do, but a lot of us, including myself, have a hard time putting it into words. In terms of the theory of the case, Tony is the guy that will explain to you exactly why that theory is going to drive everything that you do throughout the trial, no matter what stage you're at, no matter what part of the trial, that theory is going to be right there in the front of your mind. Now, the best thing that I can say about Tony as a friend of mine is that I only have one rule when I'm trying cases, and that rule that I never break is by the end of the trial, if the jurors can forget that I'm a goddamn lawyer, I've done a good job. With Tony, that's easy. It comes natural. Tony, the town.
Thank you. In the event that anyone can't hear me, raise your hand and back, okay? Is that fair? How many people have heard you have to have a theory of your case? How many people have heard that before? All right. How many people have had someone give them a definition of a theory of the case? Ooh, not so many. How many people said, you really need to have themes in your cases? How many people have showed you how to develop and have a theme in the case? Isn't that weird? It's like someone, this is what you do. What does it look like? How do I get it? Well, if we're successful, by the end of this presentation, you will really know what a theory of the case is. You will have a working definition of the theory of the case. You will know what a theme is, and you will know how to create themes, and if we have enough time, you will learn how to present it. And as Michael already told you, it will be your blueprint for everything that you will do in the next 2 weeks, not only in this case that you're working on, but in your cases at home. So does that sound fair? Does that sound fair? And if I don't do that, then you come up to me and you know what I want? You say, Tony, hey, what? You didn't deliver. So hold me to that standard. Ready? Now, people think in narrative. What do you think when I say that? What's your name, ma'am? Caroline. What do you think when I say people think in narrative? The story, right? One of the people who will be talking to you later is Sunwolf. And Sunwolf is a lawyer who was a PD for a long time and then went to get a PhD in communications and all this other good stuff. And she can tell you the science of it. But when we hear a story, different parts of our brain are actually working than when you hear a lecture. And it tends to be more memorable, and it tends to have something which allows you to stay with it if it's consistent with your values. So we know that people think in narratives, and you say, well, he's just saying. But let's think about it. Everyone do me a favor. When I ask you to close your eyes, close your eyes. All right, not now. No one will touch you. For those of you that are fearful of the people sitting next to you, no one is going to touch you. All right, Marty? Where's Marty? Marty, don't touch anybody. Okay. Now, close your eyes, and when you close your eyes, I'm going to give you a phrase. And when you see it, when you feel it, when you smell it, raise your hand to keep your eyes closed. Okay? Ready? Close your eyes. Auto accident. Auto accident. When you see it, when you smell it, when you feel it, raise your hand. Okay, the majority of you have it. Put your hands down, open your eyes. This next part, I'm going to require you to turn your heads in different directions. When I ask the question, I want you to raise your hand and then you look around the room. All right? Everyone with me? So, how many people saw a head-on collision? Raise your hand. Look around the room. Raise your hand high. Don't be shy. Okay. How many people saw a T-bone? Raise your hand. Look around the room. How many people saw a rear-end collision? How many people saw two cars? How many people saw a car and a bus? A car and a truck? How many people saw a car and a pedestrian? Or a motorcycle? How many people saw a tree or a telephone pole? Okay. How many people saw the last accident that they read about or heard about? Look around the room. How many people saw the last accident that they were in? How many people saw, envisioned the accident that you fear the most? Now, I'm very confused. I am assuming that you all went to college and to law school, right? And that you're fairly familiar with the English language. And you know I gave you two simple words, auto accident. How come none of you saw what I saw? What's wrong with you? Why didn't you see what I saw? Why didn't you see what I saw? Sir, what's your name?
Jesse.
Jesse. Why didn't you see what I saw?
I don't know what you saw.
Right. But I told you, I said auto accident. Think about this. You all, with getting two words, created a story and a vision of something that happened. But not only that, it was related to you. When I say auto accident, it's like saying self-defense. It's like saying consent. It's like saying ID. It means nothing because it means everything. It means something different to everyone. So that isn't a theory of the case. It can't be. So a theory of the case has got to be something more. Now, you peek into the window, right? You peek into the window of a room. And bam! You see me hit Jason with a straight right. What do you think? What's your name? Yeah.
Name?
Yeah.
Monica.
Monica, what do you think?
I think that Jason beat up.
No, I just come in and I go, bang! Hit Jason right on the face with a straight right. What do you think?
You heard it?
How well does she know you, Jason? Ma'am, what's your name?
Nancy,
Nancy, what do you think?
I'm wondering why you hit him.
Okay. Ma'am, your name?
Bonnie?
Bonnie, what do you think?
I think he just beat up Jason.
Okay. Do you have a view of me? Do you have an attitude of me? All right. Now, you peek into the room a little early. Oh, by the way, I may tend to use curse words. If that offends someone, I can do it without using curse words. And I'm being serious, because I've been to places where people afterwards said he shouldn't have used the curse word. Does it offend anyone?
What the fuck?
Okay. If it offends someone, don't feel shy and raise your hand. So you peek into the room a little early. And you hear Jason say, "You fucking guinea prick. I swear to God, I'm going to cut your motherfucking nose." Reaches into his pocket.
I want to hear that without curse words.
I'm going to cut your nose. Bam! I hit him with the straight right. Now what do you think? Sir, what's your name?
Chris.
Chris, what do you think?
He deserved it.
What do you think?
Self-defense.
What?
Self-defense.
Self-defense? Okay, now, you come in. You peek into the window. You hear him say, "You fucking guinea prick, I'm going to cut your motherfucking nose." Reaches into the pocket. Bam! I hit him with the straight right. Daryl comes in and says, "Cut. When we film it, do it exactly that way." Now what do you think? What's your name?
Deepa.
Deepa. What do you think?
That is all stays.
Yeah. Did the punch change in the case? Did in the three scenarios, did the punch change? It was a bad thing. Did it change? But did it give you meaning? No. It only gives you meaning if you know what happened before, during, and after. But just seeing the punch, you all came up with the story, you all had an impression. Because no one can sit there passively not trying to have something make sense. So, we've got a punch, we've got an auto accident, and you're saying, well, what does that have to do with the theory of the case? I'm going to give you a working definition. And I say working definition because it's a definition that guides your work. It's a combination of facts beyond dispute and law, which, in a common sense and emotional way, leads the jurors to conclude that a fellow person is wrongfully accused. I do a sentencing presentation, so that's what you put in here, or should not be severely punished. In your death penalty cases, that may be what we call front-loading, but I digress. Okay, so that's the working definition. Everyone have a chance, if you can see it, read it to yourself. If not, I'll repeat it. It's a combination of fact and law. Facts beyond dispute. Well, what do you think I mean when I say facts beyond dispute? Sir, with the glasses?
Casey.
Case, what's your name?
Casey.
Case, okay. What do you think I mean by facts beyond dispute?
Facts which no one disagrees with.
You can't disagree with. There was a straight right punch. The gun was unloaded, right? And we know that there's going to be certain law attached to it, right? So it's a combination of fact beyond dispute, meaning facts that you can present and prove, and law, which in a common sense and emotional way. Why do you think I chose the word common sense? I'm sorry? Go ahead, what's your name?
Marion.
Marion, what?
Reasonable doubt definition.
It could be reasonable doubt definition, but take it away from legal, Marianne. How do most of us make decisions? Common sense, right?
Yeah, but common sense not so common anymore.
Ah, common sense may not be so predictable as it is, but there is such a notion of common sense, and everyone has their own notion, right? So, it's common sense in an emotional way. We know that even when mathematicians have a problem, huh? Ultimate nerds, huh? When they get a new problem, the emotional part of their brain gets excited before any of the analytical process takes place. There is an emotion to everything we do, whether we like it or not. So, and we know that people are motivated by emotions, things that cause them to identify and to feel a particular way. Now it says leads the jurors. Why do you think I chose the word leads the jurors? Yeah, ma'am, what's your name? Nisha.
You want them to follow your story.
You want them to follow your story. So it leads the jurors to conclude. Why do you think I said leads the jurors to conclude? Sir, you got your hand and your pen? What's your name?
Carlos.
Carlos. What do you think I mean by it? What does it mean to you when it says that leads the jurors to conclude?
You want the jurors to accept the story that you're telling them. You want them to internalize it.
Go ahead. What's your name?
Nikki.
Nikki.
And it makes it feel like they're getting there on their own, not following marching orders of someone.
Ah, let me ask you something. How many people in this room, raise your hand if it applies to you, remember the day you learned that electricity was dangerous? Go ahead, raise your hand. Don't be embarrassed. Okay, ma'am, what's your name?
My name?
Yes,
Michaela.
Michaela. Nice name.
Thank you.
Michaela, would you mind telling everyone, we're not going to hold it against you, how do you remember and why do you remember the day that electricity was dangerous?
I was unfortunately at a non-child-proof home with a children's toy and an electrical socket.
Okay, that...
I got just a little bit of a spark, a little bit of shock. I didn't have to go to the ER or anything.
Okay. Anybody else? Yeah. Name?
Mark,
Mark.
when I was about 4, I
I was in the backseat of my parents' car, and the cigarette lighter that you plug in,
Oh, yeah.
popped it out and put my finger on it.
And what happened?
It was hell.
Okay, now, after that, did anyone have to tell you that electricity was dangerous? After that, if someone told you to do that, would you do it? How many people don't remember when you first learned that electricity was dangerous? I would wager that most of you didn't stick a fork into a light socket, right? Now, the reason why I give you that is because if it's our conclusion, if it's our life experiences, we hold on to it for good or bad more strongly. So you want them to conclude. How many people here have watched a TV show or a movie and you give the next line? How many people have done it? What do you do? Now, you probably don't do exactly what I do because you're not Italian. But you go, what do you do? What do you do? Particularly if you're with someone else. What's your name? Shuli. You have kids? Mom's psychic. Well, moms are, by the way. Yeah. Okay. What else do people think? What else do you do? Go ahead, sir. What's your name?
Derek.
Derek, what do you do?
I get hit and told to shut up and let me speak on development.
Yeah, but how do you feel? How do you feel?
I actually sometimes get angry because I wasted the opportunity to make some money because apparently I could write better than the story.
I can write this shit. I can write this shit. You know what I'm talking about here? I can write this shit. Yes, you had your hand up, ma'am.
I was just gonna say I blurted it out because
What?
it makes me feel like I'm a know-it-all.
Bingo. Now, why were you able to give the next line?
Because it was logical.
Maybe. Logical. What else?
Experience.
Experience. What else?
The letters led you to that conclusion.
They led you to that conclusion. It fixed in your mind. It was consistent with the narrative that you were preparing. And what happens when you're validated? Yes, sir. That's me. So that is the reason why you want to have the jurors conclude that a fellow person. This should be an easy one. Why fellow person?
Someone like that. Empathizing.
Someone like us, a human being, is wrongfully accused. Now, I get some debate with some people on this, but since I'm giving the presentation, I get to choose the words. I choose wrongfully accused. Some people like innocent. My preference, wrongfully accused. Why do you think I select wrongfully accused? Yes?
Because that implies injustice.
Applies injustice. What else? Someone in the back row. Don't sit there. I'll come up there.
I guess it implies that they actually didn't do it, not that they just have a legal defense.
Say that. What's your name?
Gary.
Gary, say that louder.
That they actually didn't do it, that they don't just have a legal defense.
Okay. What else? Yes, Nancy?
That they may have done something, but they're not necessarily guilty of what they were accused.
Ah. Okay. So it's a combination of fact and law beyond dispute, which in a common sense and emotional way leads the jurors, or I could just take off the plural and just say juror, to conclude that a fellow person is wrongfully accused or shouldn't be severely punished. Now, you're saying, okay, great. I got a definition. He fulfilled on one of the things he said he was going to do. But what is this? How do we use this now? What do we do with it? Well, I got to talk about two things. Our presentations in the courtroom are going to be two things. Particularly when how we're developing a theory of the case. It's client-centered, and we're going to have presentations on interviewing your client, but it's client-centered, but it's juror-driven. Juror-driven. It's driven by what a juror would be more likely to think, expect, see, and feel in the situation that would be consistent with that. But there's a reality that we're facing in court. How many people remember when you were in elementary school and there was the timelines? This is when the dinosaurs were here. This is when Christopher Columbus. Remember that? Remember that? Not yet, right? Now, every trial has a timeline, whether we like it or not. Right? In real life, the timeline of a case could be a matter of seconds, or it could be years. It could be a conspiracy case, it could be, but it's not gonna take that long or be that short. So what, the reality of the timeline, that's not what's going on in the trial. We have the trial though. Now, every case has what we call bad stuff. And in fact, that's the punch. What, if this is the timeline, I got my hands like this, right? How much of the bad stuff does the prosecutor want to have? What does she want to have? How much of this time spent on the bad stuff? All of it, or at least this much, right? Right? Now, if we, how much of the bad stuff do we want? Teeny tiny bit. Well, but if the timeline is this long, we have to do investigation, we have to figure out what came before, during, and after, so we can put it into context, just like we did with the punch example. So, if that's the case, we need to have some techniques, some ways of analyzing our case that'll allow us to figure out how we can shrink the focus of the presentation, of the trial, with the bad stuff's a teeny bit, and all of the context is greater. Now, pathways to theory of the case. Now, pathways, I'm using the term as different vehicles that you can use, different concepts, different ways of analyzing the facts. There is no one right way. No one right way. But I'm going to give you a variety of ways, some of which will work better in some cases than in other cases. But we're going to go through them. First one is reenactments. There's a physical reenactment. How many people here have gone to the crime? You read the police report and you go, this is bad. This is very, very bad. Right? But you go to the scene and you go, wait a minute. Go ahead, it's Nikki. Tell me about that.
Well, when you look at the police report, it looks bad because the officer presumably is wanting to support the charges that he's filed and his arrest, so he focuses on all the bad facts, but then when you go to the scene, you put it in context, you can see things that make it there.
Physically, it's impossible that this could have happened. So you go through a physical reenactment. What physically would have had to occur? Would this have happened? How could this happen? If that happened, what would be the artifacts that we would see of it? So there is a physical, minute, instant, tiny, tiny steps as to how does something physically occur. Next, psychological reenactment. Now, what I mean by psychological reenactment, what's going on in the witness's mind when this is going on? And let me give you an example. You come out of the shopping mall and you're going to your car, right? How many people, when they're going to their car from the shopping mall, walk to their car like that? How many people do that? If you are, we can get you help. How many people stream of consciousness and where did I park the car? Do I have the keys? Oh my God, I gotta pick that up. I hope this camera works. Okay. Isn't that what you're doing? You're thinking about what's going on, what's happening next. Now, you're walking. Someone pushes you from behind, right? You're falling. They grab the bag, they turn. You're falling, you turn around, and you see them run away. The psychological reenactment is a way of connecting with the reality of the situation. And when you go through it, it will give you ideas for cross-examination or to present evidence to put into context the pushing. For example, that person may say, well, I got a good look of their face. Well, in doing your cross-examination of that person, you may go very slowly through, you were walking, you were thinking about this, you were thinking about that, you're thinking about that. And then in your cross-examination, your pace picks up. And then you were pushed, you're going to the ground, you're losing your balance, You were falling, you didn't know what was going on, something was ripped away, you turned around and all you saw was the back of someone. And then you go to a slower pace. You were angry, you were scared, you were frightened. And you then do a slower pace as to what happened afterwards. So, it's a psychological reenactment. What was going on in people's head? What would the jury think could have or should have been going on that would explain the actions that they took or didn't take? Legal reenactment is when did an event of legal significance occur? When did those events occur and why? Next, another technique. Points of choice. When did a witness or the accused or the police have a decision to make which has significance? Points of choice. What was that scene? What was the context of that scene? And what were the choices that were available logically, in retrospect, and in the immediate moment? So you identify those particular scenes and you go through them. That's another way of analyzing a case. Because as we get to later, every case has questions. The perfect video analysis. This one is, imagine if there was a video camera that had audio recording capabilities, and it was recording every single thing that occurred everywhere, right? Now this is one you got to use your imagination for, and most of you before you went to law school probably had. And in certain areas, probably most when you're in the shower, you still have it. But Derek, I think you and I are going to get along fine. Okay, now, what would the perfect video of guilt show? There would be confessions, there would be, all the evidence, there'd be fingerprints, there'd be DNA, and you do, what would the perfect video show? What would the perfect witness be able to say, and what would corroborate? Then you do the perfect video of innocence. What would that show? What would be there? What should be there? What would it look like? What do we think a juror would expect? Now you take those two and you compare them to the facts in your case. And you say, what is consistent with guilt? What is consistent with innocence? And then you begin to go through that process to see if that's helpful in order for you to frame what your theory is going to be and how you're going to articulate it. For example, there is often disagreement between people as to what something means to them, how it means to them, but yet it's their expectations. So if the witness has an explanation which is contrary to what the jury would expect, that may be to your advantage. So there's the perfect video analysis. Good stuff, bad stuff. This is the one that everybody knows, right? What's good? That's good. What's bad? That's bad, right? The problem with that is that sometimes you get stuff which could go either way. And I'm going to save what you fear the most. I'll go back to that. What do you see here? What do you see here? Who sees two people? Who sees a vase or a goblet? Who switches between the two? Now, this is where voir dire comes in. And I'm not going to talk about it because Sunwolf is the expert, without a doubt. But this is where, when someone hears something, hears a situation, you've got to know what their values are, how it strikes them. Because just because you're going to argue all day it's a face, someone may argue it's a faces, and someone may say it's a goblet, right? Someone may say, well, it's both of them. And if it's both of them, what does that really tell you? Does that really help either side? So, and there's one, which if everybody's good, I'll show you later, which is an optical illusion. I'll tell you what it is so you can look it up if I don't get to it. It's called dolphins in a bottle. Huh? Dolphins in a bottle. And what's interesting about that illusion is that depending on your age, you see two different things. Huh? I want to go back. What do you fear the most? What do you fear the most when you read this case? This is another way of analyzing it. What are you most afraid of and why? List it, write it out, articulate it, talk about it. Why are you afraid? What causes you to be afraid? And what would some ways make you feel better? The next thing is, what do you think the jurors may fear most about your case? That's another way of analyzing it. And as I said before, there's no one right way. You can use a variety of these techniques, and you probably should. Questions to be answered, right? Now this may sound a little bit covered in some of the others, but questions to be answered are, what are the obvious questions that a juror is going to want to know why your person has been wrongfully accused? Right? What are the questions? Well, for example, why did he reload the gun twice? Wasn't 21 stabs enough? There was no need to go to 42. Right?
You gotta be sure.
Right. You gotta be sure. Okay. That's what you call these people obsessive compulsive, right?
Electric knife.
Electric knife. Cut that out. Told you I wouldn't bring you here. Okay, now, so there's questions to be answered. We may not get them all, but if you talk to people who are non-lawyers, they will help you, which is another way of planning and testing your theory of the case is with people who are non-lawyers. What do they think? What do they do? So there's questions that need to be answered. Now, this I stole from Sunwolf. Sunwolf, who has done probably the best research in the entire country on juries and jury deliberation and juror behavior. Did her, and if I'm taking any of your thunder, tell me to stop. Are you mad at me? Who? Sunwolf? Okay. This is what jurors really do when they're deliberating. And she did a study of real jurors, real videotapes of them, and her study shows that they have a what-if story. That someone will argue, what if this happened? Some may have an if-only story, if only this. Others may have a common knowledge framework or story. Everybody knows this. Somebody has the personal knowledge. My Uncle Joey, huh? And they talk about it. Some have a reasonable person. These are the people who like to think of themselves maybe a little more intellectual. Yeah, a reasonable person would do that. Oftentimes, it's guided by hindsight. And then there's the conspiratorial theorist type. Let me tell you what I think really happened. Now, I point these out to you because they are real, they are obvious, and it is proven that this is what jurors do in the jury room. So, in developing a pathway to your theory of the case, you need to think of what are the what-if stories? What are the only-if stories? And how can I deal with them and try to address them in my theory of the case? Now, I hope I've just showed you how you investigate, how you analyze, and in order for you to develop your theory of the case. All right? Now, the next thing I want to talk about is hooks. Hooks are the things that get our attention. You know, we always hear primacy and recency, the first thing that you hear that, right? But it's true. So you need a hook. I want to talk to you about a couple of different hooks. The first one, I really need your help with. The first one is a headline. Bless you. Now, How many people have had a case where the headline in the newspaper the day of jury selection or just before was, hopefully the bastard gets convicted this time? Or, you know, like, dirty bomber, hopefully he'll rot in hell, you know? Things like that. How many people have had a headline like that, right? We tend to frown on those things, right? This is a fantasy exercise, all right? But it's important, so stick with it. Every one of you own the local newspaper. You're the only writer, you're the publisher, you choose everything in the newspaper. And guess what? Everybody in town who's going to be on your jury has to see the headline of your paper before they come into jury selection. Imagine that, right? Now, are you one of these, like, fair and balanced? No, because you're the defense lawyer. You're defending the person. So, you want to have a headline. I'm going to tell you now a short case. Young kid, good student, 16 years old, just got his driver's license. Uncle, scumbag, 4-time convicted meth addict. 37 years old. Scumbag uncle says, hey, how about driving me to the 7-Eleven? Get to practice your driving. Kid says, sure. Kid gets behind the wheel of the car. They drive to the 7-Eleven. They go into the 7-Eleven. Scumbag uncle pulls out a gun, points it to the clerk. He says, give me the money. The clerk says, ah? Bang, bang, kills him. Turns to your client, right? Turns to your client and says, get the money. Your client gets the money, they both run out, and since this is a 7-Eleven that serves coffee and donuts free to the local police, before they can get out, the police are there and they get arrested. Everyone understand the facts of this case? Now, you represent the kid. In 10 words or less. Now, I know the appellate people are saying, well, with special dispensation, can I go to 11? 10 words or less. 10 words or less. I want the headline that you would write that would explain and bias in your favor the jurors. But it has to be a combination of fact, law, beyond dispute, which in a common sense and emotional way leads a juror to conclude that someone has been wrongfully accused. That's the definition. It's got to meet that definition. 10 words or less, pens, paper, put them together, engage the mind. When you have one, raise your hand. When you have one, raise your hand. 10 words or less. What's your name?
Nick,
Nick. Shout it out, boy.
just one thing to clarify, you said the guy was 11, right?
No, he was 16. Say 16,
Okay,
17.
doesn't change it.
Well, you can just change the number. Good.
Armed robber forces juvenile to participate in robbery.
You got it written down?
No,
Write it down and then come down and see me. Yes, what's your name?
Arturo.
Go ahead, Arturo.
Yeah. Keystone Cops, mad, clean kid.
Come on down. We'll see what we're going to do with that. Come on down. Come on down. Who's got another one? What's your name, sir?
Seth.
Seth, what do you got?
Kid robs store to avoid getting shot.
Come on down. Sir, you had your hand ready. What's yours?
Convicted felon forces college student.
Louder, please.
Convicted felon forces college student to commit crime.
Make him a high school student, because he's not that bright.
High school student.
Yeah, because like 16, you know. But that's good enough. Come on down. Okay. So everyone I asked to come down, come on down.
Does it need to be written down?
Well, if you can remember it, fine, but it's better if you have it written down. Yes, Ms. Laurie. Oh, come on down. Come on down. Have we met before? Have any of us met before? Have I given you anything before? Is there anything up my sleeve? Okay. Wait a minute, there's someone else who's supposed to be here.
He's coming.
Where is he?
I'm writing it down.
Okay. Oh, by the way, I tend to be very understanding and not very demanding, if you haven't noticed that. Okay. We're just going to take them in order. Now, there's no one right headline for a case. There's no one right one. It's the one that you feel you can best deliver. But you got to think about it. So let's start with this one. Adrian, go ahead.
Convicted felon forces high
Louder, come on, be proud.
Convicted felon forces high school student to commit crime.
He starts with the convicted felon. Forces. High school student. What's better than a high school student?
Honor student.
Hey, honorable student! Huh? All right? Now, when you hear that, what comes to mind? That poor kid, how did it happen, what goes on? Does that focus the attention? Obviously it does. Does that have facts beyond dispute? Does it have law? Does it have everything? Absolutely true. Let's go next. Arturo.
Keystone Cops, NAB, clean kid.
Excuse me for standing in front of you. Okay, Keystone Cops. That's making an assumption. What assumption is it making?
That the cops have bungled this, or that they've made an obvious Three's Company type error, mistake of
Okay, wait a minute. Who robbed the store?
scumbag,
And who else was there?
my innocent kid.
Okay, so they were there, right? So they really just didn't pick someone out of the woods, right?
Right.
And is there anything that the cops did wrong in this case?
Rush to judgment.
Well, no, they arrested everyone the prosecutor made. The decision to prosecute him, right?
Yes, but I think arresting everybody and letting the prosecutor sort it out is Keystone Cop.
Okay, but do you think the jurors believe that? When they hear this situation, are they gonna think the cop should have said, oh, we're gonna let the kid go? At the scene? Okay. So what I want you to think of is, don't try to sell something that's gonna be hard to sell. What else do you have that?
Clean kid.
Clean kid. See, he's got the alliteration going. Clean kid, really good. But think about the Keystone Cops. Is this really the cops' fault? Or is it really the scumbag uncle? Which is easier for you to prove? Now, if you want to go with Keystone Cops, then you've got to show that these guys were bumbling clowns. Which, is that based on the facts or based on your perception? You got to think about that. Next one.
Armed man forces juvenile to participate in robbery at gunpoint.
Armed man. Come on, you can do better than that. What's worse than an armed man?
I don't want to repeat robbery.
Gunman.
You can, well, then, what's another word?
Criminal.
Help him, help him. Felon.
Method.
Meth head. How about crazed armed meth head? Now,
Armed felon forces juvenile to participate in robbery at gunpoint.
forces to participate at gunpoint. You're burying the, what's more persuasive? Having gunpoint at the end or putting it in the middle? Say it with it in the middle.
Okay. Armed felon forces juvenile at gunpoint.
Because now you've told how he was forced. What do most people say if at gunpoint? Yeah, it's kind of forced, right? There's a reasonable disincentive, right?
Right.
Okay, but you see how we can manipulate the words to get a sharper focus for us? Seth?
Kid helps rob store to avoid getting shot.
Kid, well, we can maybe expand it. Avoid getting shot. Different approach. This is really, doesn't that imply that he thought he was going to be shot? Isn't that kind of nice? See how he did that? Now, does he rob store or does he go along?
Helps.
Or you may want to think of helping. You got to think of a word that is more with someone being forced.
Force.
Sounds like. Okay. But you see how we can play with it? We can either start with the good kid, the bad tragedy. This is a little more obtuse, because now, what's family loyalty?
Oh,
What is-
we've all got one in our families, don't we?
What does that mean? Now, that will give you something that you can use. It's a different framework. Is it as specific? No. Does it have to be as specific? No. It's what you feel most comfortable with. But remember, when you say family loyalty, that may be like saying auto accident, right? And was it really family loyalty that caused him to get involved, or was it the 9mm pointed at? So you've got to figure out which one it is. This is something that you can, like, leads to tragedy. She's totally recharacterized. This is a tragedy. Who's it a tragedy for?
My client and the other there's two victims.
So you see how she took the word robbery out of this and put it into a tragedy, which puts it in a whole different context. Thank you very much. Okay, you ready? I would strongly recommend that in every one of your cases, at least try to have a headline. Try to develop a headline in the case, because it allows you to focus and then to play with words and how to paint the picture that you want. Also, a headline is a great way to begin your opening. Next, sayings. Proverbs and sayings. How many of us grew up hearing those things? They mean different things to us. Can anyone think of a proverb or a saying that might apply to this case we're working on here?
Pick your friends, but not your family.
Oh, say it louder.
You can pick your friends, but not your family.
You can pick your friends, but not your family. Might that be a hook? Might that be something you can start your opening with? You can pick your friends, but you can't pick your family. So there might be a saying that expresses it. Trilogies. You're going to hear that over and over again. Everyone loves trilogies. Everyone loves alliteration. Can you think of 3 words that might relate to this case we're just talking about? 3 words. Some of them begin with F. 3 words. Yes, what's your name?
Greg.
Greg.
Trust, love, and a gun.
Trust, love, and a gun. Okay?
Ben.
What?
Family, fear, and force.
Oh, say it louder.
Family, fear, and force.
Family, fear, and force. You can think of things like that. How would you start your opening? Family, fear, and force. And then you can go and tell your narrative. That is what a hook is. Question. Some cases lend themselves to a question. Can anyone think, and again, not every case lends itself to, but anyone can think of a question that might be your hook.
What would you do if your favorite uncle robbed a store from you, or what would you do if your...
Make it simple. With Catherine. Catherine?
Yes. What would you do if your family...
Go ahead. You're in line.
Did he have a choice?
Did he have a choice? Or what choice did he have? What could he have done? See how you can use that as your first thing that comes up? And then everything will flow from that. Now, those hooks that I went through are just some of the things that you can use as a hook. These hooks oftentimes can become themes. The phrase can be something that is repeated. The question becomes something that can be repeated. It's something that you will use in your voir dire. It's something that you will incorporate into your cross-examination if you can. For example, cross-examination of the officer. it's a scary thing when a gun is pointed at you. It's a scary thing when the first time a gun is ever pointed at you. You would agree it's a scary thing when you think someone might use that gun against you. Do you see how you can use that, some of those forced fear, into your cross-examinations? Now, this applies to everything that we do outside of the courtroom and in the courtroom. But we got to talk about it. There are three components of a persuasive presentation. There's a technical approach. What technique are you using? You will learn in cross-examination, it's short, closed-ended questions. That's a technique. Voir dire, open-ended questions. You will learn that there's pacing. You will learn a number of techniques here. Just like when you were playing the piano or you were learning any sporting event, there was the right technique. And what does the right technique enable you to do? It's, Luke? Oh, I'm sorry, I can't see from Chris. The right technique. What do you play any sports? Have you ever played sports?
Yeah.
What sports?
Hockey.
Hockey. Okay. Are there any particular techniques that you learn in hockey?
Sure.
Like what?
Skating, stomping,
Right.
shooting.
Are you from Boston? and for my next act, I might be a Bruins fan. It was so cold. This is true. So cold last night in my room that and I've told this to other people on the faculty, they can tell you it's true. It was so cold last night, I dreamed I was skating on the road. But, so there are certain ways, right, to stop, right? There are certain techniques that you learn that make it easier to shoot, right? If you try to do them in a different way, it's not as effective, right? So there's the technique. Am I using the right technique? Substance. Is the subject matter of what you're talking about necessary to further your theory of the case? Is it necessary? Does it resonate with the jury? Are they going to see and understand why it makes sense? There's a substantive part of what you do. Sometimes we've been having people what we do called content-less cross-examination. They have the technique down, one fact, but yet they're not getting at anything that's significant. Yeah? It was, yeah. So, substance. And then the last thing is emotion. There has to be an emotion which is consistent with what is going on. You cannot project your emotions onto another person. How many people here have felt very affectionate towards someone who didn't reciprocate? Huh? How many times did, the more you tried, the less you got back? So emotion is something that you have to be careful about, is what is my emotion, and is it real, and is it appropriate? The more important thing is, what emotions do I want to try to create in the jury? And you want the circumstances to create it, and not just you showing it. Because remember, a trial is a live event. Now, okay, the last thing I'm going to put up is this one, and then I'll end. People learn in all different ways, and there's no one right way that everybody learns. But think about yourself. Some people like to read stuff. Some people like to hear it. Some people have to see how it works, or actually physically, wait, this way. They have to physically touch it. They have to see how things operate. So when you're making your presentations, be it cross-examination, direct, think of it, or even interviewing clients. Am I stuck in audio? Am I being visual? Am I using other stuff? What am I using so that regardless of whether this person is dominant in one area or not, I am communicating it stylistically in a way that helps them? For For example, client interview. You're looking at a mandatory 15 years. Well, you're saying that. What about, let's see what the statute book says. Statute, do you want me to read it, or do you want to read it? Now, why do I ask that? Because if the first says, no, you read it, that may tell you something. That may tell you that they have a reading problem, maybe not, but it could. But in any event, you then go through it with them. So now you've showed them, you've allowed it to read, to read it, and it's something that has more credibility than just you saying, hey, this is what you're looking at. Now, you are going to spend most of today using these pathways, using this definition, to develop theories of the case for whatever case you've been assigned. In your sessions, think about what technique can we use? How can I use it? How can I get there? What might it be? What is most comfortable for me? Remember, throughout the entire 2-week period, is what I'm doing, is this furthering the theory of the case? Does it connect? Am I using the right technique? Am I using the right substance? But most important during the next 2 weeks, understand that everybody here does the same thing. Everybody here is to help other people to do better. This isn't, does my star shine brighter than yours? This is, how can I help you and you help me to do things better than I'm doing it now? Because ultimately, we're here for the clients. And unfortunately, unlike med school, where they start cutting up dead people and then they work the live ones, they don't do that. So everything that we're going to be doing here, even if you've had a trial ad course, is probably unique because you're going to practice it, just like any other performance art is practice. If you have any other questions, you can ask me afterwards, but thank you for your time and attention, and have fun.